So now we will turn to our panel on balancing patent rights and litigation abuses. I think we learned this morning U.S. patent law has been an essential contributor to the innovation and competitiveness of American business for over 200 years, and perhaps never more so than today. And as we also discussed, at least touched on this morning, we're in the midst of a movement to revise patent rights, a movement that began again almost as soon as the America Invents Act took effect a little more than 3 years ago. Our panel this morning now is going to discuss those legislative attempts to revise patent rights, an attempt, I take it, that is intended, among other things, to rein in litigation abuses that we also touched on earlier this morning. For details, we're now going to turn to our panelists, Professor Adam Mossoff, Mr. Noah Phillips, and Professor Scott Keith. I'm going to introduce them very briefly so we can do a bit of catching up here. We're going to go a little bit long on our panel this morning. We will get to your questions as soon as possible. Professor Mossoff is a professor of law at George Mason University School of Law. He's also the co-director of academic programs and a senior scholar at the Center for the Protection of Intellectual Property at George Mason. He's also that center's co-founder, which dates back to 2002. There he teaches and writes in the areas of patent law, trade secrets, trademark law, property law, and internet law, and he has published extensively in all things IP. Mr. Noah Phillips is chief counsel to U.S. Senator John Cornyn at the Senate Judiciary Committee, where he has served since September of 2013. Prior to that, he was 2 years in a counsel position to Senator Cornyn, and before that, he spent just over 5 years in private practice at 2 major law firms. He's one of the, I understand, primary forces behind the current legislative efforts around patent rights. Professor Scott Keith was sworn in on October 18, 2013 as a commissioner of the U.S. International Trade Commission. I guess I should refer to you as Commissioner Keith. Before joining the ITC, Commissioner Keith took a leave of absence from his post as a professor at the George Washington University School of Law in Washington, D.C., which he joined in the summer of 2009, having come to GW from Washington University in St. Louis, where I think, interestingly, he was a professor in the School of Law with a secondary appointment in the School of Medicine's Department of Neurological Surgery. Their much longer bios are available at the Federalist Society's website, so I've been brief so we can get right to the substance. We're going to hear opening remarks from each of our panelists in the order I just introduced them, then some discussion, and then, of course, your questions. With that, Professor Mossoff.
Thank you, Dean. I thought it was really great that Judge Michel began the discussion this morning by talking about the extensive rhetoric in the patent policy debates, and that the patent policy debates are largely dominated and framed by rhetoric and not actual facts or data. And this has been particularly true, unfortunately, in discussions about patent litigation. One often hears complaints about a so-called patent litigation explosion, typically caught up with complaints about the smartphone wars. You hear attacks on patent licensing companies smeared by the epithet patent troll, which has no real definition. And what ultimately you have going on is what's driving a lot of these attacks and a lot of this rhetoric is, of course, is that certain companies that do not have patent-based business models are leveraging millions of dollars in lobbying and PR efforts to attack the patent system, to weaken patent rights, to clear the way for their business models. And in fact, consistent with what Judge Michel said this morning, David Kapos, the former director of the Patent Office, has repeatedly referred to patent policy debates as a fact-free zone, which I think is a really great characterization of what's going on right now. Although I think it's even worse than being a fact-free zone. I think it's a fiction free-for-all zone. Because what you've got is not just no data, which was a big argument that you heard today, this morning already. The theory is outrun the data. You actually have arguments, appeals to specific types of numbers and claims being made in the debates about patent litigation that are only true because they've been repeated so many times in the patent policy debates. They've become accepted as truth. But in fact, they are completely untrue and bear no relationship whatsoever to what's actually happening in the real world in the innovation industries or in the courts. To take just but one of many, many, many examples, something that has been repeated again and again and again for the past 3 years is a claim that one often hears is so-called patent trolls have caused $29 billion in damages in the year 2011 alone. That, my friends, is a completely made-up number. It bears no relationship whatsoever to the real world. It was a number that was produced from secret data obtained from companies like Patent Freedom and RPX, who have a specific business model and policy interest in attacking patent licensing companies and patent litigation, and creating the appearance of patent litigation. And it's based upon a definition of what counts as a patent troll that would include individual inventors like Thomas Edison, Nikola Tesla, companies like IBM, and many, many, many others. So this really has become a serious, serious concern when you have proposed legislation, such as the very first piece of legislation that began the recent spat for push for revision of the patent litigation practices back in 2013, where this number is being invoked as the justification for this. So we have to really, I think, step back and really start to question what is happening today and the impact that this might have on the innovation industries and on the companies and individuals who create patented innovation. Another example of a concern where the rhetoric, as I said, isn't just not supported by data, actually is contradicted by the data and therefore is false, is the claim that there's a patent litigation explosion today. And in fact, historically, patent litigation rates have been clearly within historical norms, which have as a general matter, ranged between 1% and 2%, but even in the 19th century, went upwards to 3% and 4% at times, and as established by economist Zarina Khan at Bowdoin College. And patent litigation rates in the past 15, 20 years have fluctuated wildly between around 1.5% and 1.7%. Clearly, not a patent litigation explosion. And in fact, the recent numbers have shown actually that we've had the exact opposite. Just this past month, the data has come out on patent litigation rates this past year, and patent litigation rates this year are down. The numbers are in some dispute, but it's between 30% and 40% drop in patent litigation this year compared to last year. So we don't have a patent litigation explosion. We never did, and even if we did, there isn't certainly one occurring now. Now, ultimately, what all of this rhetoric has been driving, of course, is a push to, again, further revise the patent system after we just adopted massive revisions to the patent system, the American Invents Act of 2011, with a push here on Capitol Hill to revise it once more. Now, one of the things that has captured the imagination of free market advocates, particularly libertarians and conservatives, is the framing of the need to reform patent litigation as a type of tort reform. And this seems very appealing. Patent infringement is actually a tort. And so the sense is that the patent system and litigation system, trial system, is being abused by bad actors. And of course there are some bad actors. That's undeniable. The FTC just recently settled with one particularly notorious bad actor. But the concern here is that anecdote and a couple bad actors are allowing the policy debate to be driven, supported by made-up numbers and actually factually untrue numbers. Because it's important to remember that patent infringement is not just a tort. Trespass is a tort. Enforcement of your property rights is a tort. And if you make it harder for someone to enforce their property rights against infringers, for instance, someone who commits trespass, someone could characterize that as a tort reform. And I teach property, and I often teach many cases involving obstreperous, difficult property owners who are bringing numerous amounts of improper lawsuits, trespass lawsuits, nuisance lawsuits, and other types of lawsuits based upon their property rights against their neighbors and fellow property owners who live around them. And so one could easily recognize that, well, we need to address this bad situation. But in adopting a systemic change to the ability of people to bring, for instance, trespass lawsuits against infringers who are walking upon their property, you are actually not just addressing that one obstreperous bad property owner, you are in fact impacting all property owners. And in fact, what you are doing, therefore, is weakening property rights as a whole. And therefore, you're hurting actually good property owners. And in fact, I think it's very important for us to remember here that tort reform is not the same thing as revising the patent system. Patents, as I think was well established this morning, are property rights. And weakening property rights is not the same thing as tort reform. And if you make it harder to enforce property rights, especially property rights in innovation, you're going to incentivize infringement. In the same way, if you made it harder for people to sue for trespass on their land, you would incentivize people to commit trespass. And by incentivizing infringement, you increase the risks to property owners to create and license their new creations. Because why would they want to create new products if people could easily take them from them and not suffer the repercussions because it's much harder to enforce those against them? So in conclusion, and kind of opening remarks, I just wanted to just emphasize again that strong property rights are the foundation for a flourishing free market, which itself is a foundation for flourishing lives, strong economic growth, and high standards of living. I mean, this is well established by the United States of America in the past 200 and some odd years of its history. And free market advocates, libertarians and conservatives, seem to have forgotten these points when they've been talking about property rights and innovation. And they've gotten caught up in a debate that has been pushed by companies and individuals who are opposed to either property rights and innovation and or have business models that are not predicated upon the creation of property rights and innovation. And so what we are constantly hearing from Capitol Hill is we need more legal changes to the patent system. Well, this has two byproducts. It either creates uncertainty for current owners or future owners of those property rights and innovation, or more specifically, what the changes do is they weaken these property rights. And both of those will have horrendous effects because it creates a very bad climate for innovation and the business models that do depend upon the creation of patented innovation. The companies and individuals who invest hundreds of millions of dollars each year, if not billions of dollars, to come up with the types of technology in the high-tech area and in the biotech space that makes all of our amazing lives today possible. So thank you.
Mr. Phillips, perhaps a different view.
Indeed. I'm a bit under the weather, so I'll stick with the prepared remarks and then turn to a little bit of what Professor Mossoff said. But I'd like to begin by thanking Dean Reuter and the Federalist Society for hosting this conference and for having me and the rest of the panelists here today. I don't think there's any group in this country that does a better job of fostering discourse and debate about all aspects of the law from the Constitution there on down, and I'm humbled to be a part of that. I would like to note at the outset that I'm here in my personal capacity. I am not speaking on behalf of Senator Cornyn, and so my views should not necessarily be taken as his. I do want to start with some facts about what we have been seeing over the past several years in terms of patent litigation. From 2009 to 2013, patent litigation in US courts doubled. From 2000 to 2013, I've seen estimates that go from 6 times to 10-fold. By any measure, that is a tremendous increase. I understand Mr. Mossoff's objection because of a denominator, and we can talk about that later. Non-practicing entities, or NPEs, account for an increasing proportion of this dramatic growth. In 2013, some 63% of patent infringement cases were brought by NPEs. Just by way of reference, in 2009, it was less than 30%. About half of all patent cases in the United States are filed in 2 jurisdictions, the Eastern District of Texas and the District of Delaware. The kinds of firms that are targeted with patent infringement litigation have changed over this period. Technology firms have long faced a great deal of patent litigation, also brought a lot of patent litigation, and specific tech firms continue to defend the most infringement lawsuits. But as an industry, at least according to Fortune magazine in a recent article, it's retail that's on the receiving end of more patent lawsuits. Retail, financial services, hotels, auto manufacturers, the list goes on. A rapidly expanding number of industries are getting hit. And by one account over the past decade, the number of businesses facing patent litigation increased by 900%. Sometimes the defendants are large firms, but more often than not, they're small firms. Startups are replete with stories of getting demand letters or patent infringement complaints filed whenever they are about to close on a new round of financing. So defendants vary widely by industry, and they vary widely by size. What are the common features? According to a recent study by researchers at Harvard University and the University of Texas, two things in particular distinguish patent infringement defendants, or the defendants of lawsuits by non-practicing entities today: cash and the likelihood that a defendant will pay out that cash. Those are the distinguishing features. The study also found that NPEs are much less likely to target firms that have large legal teams and much more likely to sue firms that are busy with ongoing non-IP related cases. This is not how practicing entities behave with their patents, by the way. And it's not about the money being made from infringement. It's about finding an easy mark and targeting them. For lack of a better way to put it, and I apologize if this is juvenile, that is trolling. This dramatic rise and shift in the nature of patent litigation is not normal. It is not the inevitable result of some recent spate of technological innovations like farm tools a long time ago. And it does not appear to reflect newly rampant infringement. It is, however, very, very expensive to a great deal of people. And there isn't any good evidence to suggest that this dramatic new expense is leading to dramatic new innovation itself. Quite the contrary. The cost of patent litigation has gotten so high and is spread so wide that it threatens the very innovation the patent system exists to incentivize. Don't take it from me. I'm going to leave out Besson and Muir because Professor Mossoff doesn't like to talk about their study. So I'll cite two others. Scholars at Harvard and the University of Texas found that NPE litigation causes firms to decrease spending on innovation, specifically internal R&D and the purchase of R&D projects. Catherine Tucker of MIT's Sloan School estimated that frequent patent litigators drove down venture capital investment over the last 5 years by some $20 billion. To go back to Besson and Muir for a moment, not to quote their number, they wrote that publicly traded NPEs cost small and medium-sized firms more money than these NPEs could possibly transfer to investors. This reduces the net amount that firms of any size have available to invest in innovation. So there is a problem with patent litigation in the United States today, and it has become a drag on the promotion of progress of science and the useful arts. I'm going to turn to what's going on in Congress, just so that everyone is sort of aware of where we are. In 2011, the President signed the America Invents Act, the first major reform of the patent system in decades. Among other things, the bill provided certain limited ways to challenge patents without litigation. With one exception, the AIA did not tackle the patent litigation I have described. So, in 2013, members of Congress began working on legislation. They introduced bills in the House and Senate, some targeting non-practicing entities, some targeting patent quality, others litigation economics. And 1 year ago, almost to the day, the House passed 3309, the Innovation Act. It passed overwhelmingly, 325 to 91, with almost all Republicans and the bulk of Democrats supporting the bill. The administration supported the bill. The Senate Judiciary Committee began to negotiate. A bill was listed for markup, and a number of members ultimately reached a compromise in May. Then, Majority Leader Harry Reid reportedly told Chairman Patrick Leahy to pull the bill from committee consideration. Thus ended patent reform last Congress. Last month, Republicans took back the Senate. Conventional wisdom, which is sometimes right, holds that a patent bill is more likely to pass a Republican-controlled Congress. Yesterday, Dean sent us some questions he'd like us to address. One was how to balance the rights of patent holders with a desire to tamp down on litigation abuse. If you take the Innovation Act as an example, one way to do so is to come up with neutral rules that encourage good litigation behavior and deter abuse. A few examples. Require plaintiffs to plead their theory of infringement by heightening pleading standards. This rewards due diligence before filing narrows the case, and discourages using patents as lottery tickets for litigation. Create incentives for parties to conduct claim construction, that is, patent claim interpretation, early in the case, so that the parties know early what they are litigating. And encourage courts to shift fees against the losing party, whether a plaintiff or a defendant, if their case falls outside the bounds of the acceptable. These are common sense rules. Do they raise the cost of bringing a case? For some litigants, yes, but not by much. For the frequent litigator, more so. For the plaintiff relying on imposing a high cost of discovery to extort a settlement, more so. For the party asserting clearly invalid patents, more so. Are they worth it? I think yes. I'd like to take just issue with two things Mr. Mossoff said, and I apologize if I'm going over. The first is with respect to the issue of rhetoric. This is a matter of public debate, and so we hear rhetoric. I'd note that the rhetoric that we hear from the side that opposes reform, that these are horrendous things that are going on, that they're going to stifle innovation and prevent all sorts of business, are exactly the same rhetoric we have heard when the Supreme Court made it a little hard to get an injunction in federal district court. It's the same rhetoric we heard with the AIA. After each of those things happened, the sky did not fall, America did not crumble, and we continued to have a vibrant innovation economy. So it's important to note that there is rhetoric that perhaps sometimes can be overstated on both sides of this debate. The second thing, Professor Mossoff thinks that all that is driving this is lobbying and PR by firms that aren't involved in the patent space. As a threshold matter, that's not true. And it's important to note that there is a fair amount of lobbying and PR on the other side of this. So it's important that when we factor that into the discussion, we understand there are two sides to it. I'm sure I've gone long over, so I'll turn it over to Scott.
Well, thanks. It's really a pleasure to join the dialogue, and I think it's essentially a key feature of Federalist Society debates that there are multiple views presented. And so rather than take one of the sides, let me first point out that I can't and am not here to speak on behalf of the International Trade Commission or my fellow commissioners or our staff. And I similarly can't and won't take position on any of the specific policy questions put before us. And so instead, I hope to offer a slightly different contribution, which is to provide just a little bit of context, a little bit of history, and some framework for ideas, because ideas sometimes really do matter. First, just to touch on and to re-highlight some of the things Chief Judge Michel pointed out and Commissioner Wright and Alden Abbott echoed this morning about the way that patents can be helpful, and in particular to think about the mechanism by which patents can be most helpful. They can do many things. They can provide incentives to invent, and they do that. They can provide incentives to disclose, and they do that. But in addition, and most importantly, when patents are at their best, they facilitate commercialization. And they do it in a way that the great Northeastern University, Yale University, its first PhD economist, an economist famous for thinking about a range of topics, Irving Fisher, just over 100 years ago, wrote a story about the inventor who invents and invents a wheelchair. He used a different word that we would not enjoy today for helping people who needed that help, and thinking that the best way to provide that help to those people who needed it was to dedicate the wheelchair to the public, not to seek a property right in it. And as a result, nobody commercialized that wheelchair and no patient got to sit in it. And the framer of the patent system that the United States enjoyed for the bulk of the last century, the principal framer, later Judge Giles Rich, invoked the wheelchair example from Irving Fisher when writing about the role of patents as tools for facilitating coordination among the complementary users of an invention. The venture capitalists mentioned earlier, but also the manufacturers, the marketers, the distributors. All of those people have to come together and interact with each other for an invention to get put to use. And that coordination problem is a tough nut to crack. But if you turn out all the lights in this room and close the blinds and make it pitch black and give somebody, any one of you, a light, everyone in the room knows something as soon as that light gets turned on. They know who's got it, because all they have to do is show up at the light. And like a beacon in a dark room, it will draw to itself all of the other people who are interested in that same light. And so if you show up because you're interested in buying, renting, using, loaning, mortgaging, securing, in any way interacting with that asset, who will you find there? You'll find the person who's holding it and everyone else who's interested in it. Property rights can be very helpful in drawing to themselves all of those different people so they can transact with each other. That's a story of patents in a helpful role, and it's a story that leading commercial jurists of the last century, like Judge Giles Rich, who happened to have been a Republican, an Eisenhower nominee, and Learned Hand, who happened to have been a Democrat, generally thought of as a centrist Democrat, and Judge Jerome Frank, generally thought of as a progressive Democrat. Each of them happened to have written in the mid-1900s about this role of patents as a crucial role of patents. And it's a story to pick up on this morning's theme of patents and antitrust. It's a story that was told very explicitly before Congress during the multi-year debates that led up to the 1952 Act, and in no uncertain terms retold by the United States Supreme Court in the 1980 Dawson decision as it exhaustively rehearsed and restudied the countless debates about the interface between patents and antitrust during the mid-1900s that led up to the 1952 statute. So that then brings us to the specific topic of the second panel today, this panel, which is to focus on litigation and patents. And one of the good places I like to start, we in the international trade community just every 2 years get together for a bar association gathering at the Court of International Trade in New York, and yesterday we were all together, and the chief judge of the Court of International Trade pointed out that it's helpful to look at the rules of the game, the federal rules of civil procedure, if you will. And the rules are all important, but first among equals is, of course, rule number 1. And why not start there anyway, since it's number 1? And Rule 1 points out that when thinking about how to improve the system of litigation, as we should always do as we participate in it, we should focus on, to quote the rule, the just, speedy, and inexpensive resolution. And it turns out, of course, that those terms, just, speedy, and inexpensive, are simple, but also complicated. And it is then worth asking about another 100-year-old economist from the Northeast. This one not at Yale, but at Harvard, Frank Taussig. Taussig, who became eventually the first chairman of my commission, the International Trade Commission, its predecessor, the Tariff Commission. Taussig pointed out when creating the International Trade Commission that an essential feature of it had to be that it not take policy positions and that it be structured in a way that removed it from political debate to the greatest extent possible. And some basic rules helped accomplish that. 3 commissioners, no more than 3 commissioners from either party. That's odd in Washington. Most of the so-called independent commissions have an odd number of commissioners. Ours has an even number, 3 and 3, and a chair rotating every 2 years, person and party. Most other commissions, including this morning's discussion of the Federal Trade Commission, has a chair who can and often does sit for the entire term of the president. The independence created by rotating chair, by a 3-3 commission, by a commission that can outvote the chair on even mere administrative matters by a 4 commissioner vote, creates a radically different system for adjudicating really anything, but including patents. And so the Patent Office, of course, is an executive branch agency designed to consider policy, designed to be politically responsive. The courts are expensive, and they do take a while. The ITC does patent litigation in about 18 months. That's much faster. But, of course, the ITC issues exclusion orders, which are akin to injunctions and raise many of the concerns. And so as we think about what are the goals of the reforms that people are discussing and what are the goals of a good system, presumably, as Rule 1 points out, you want justness, you want speed, you want low expense. But then the question is, what are the mechanisms by which you can accomplish those things? And I presume we'll talk more about that, so I'll leave that out there as a teaser. We'll try to tie things back together during the discussion. Thank you.
Just briefly, if I may, I once had a partner in private practice for whom I worked who really wanted to litigate a Rule 1 case.
We may have our chance.
All right, well, thank you very much. I think we're off to a good start here. We do want to get to the audience questions as soon as possible, but before we do that, I want to turn back to Adam and see if we can get any further, any closer to agreement, or talk about the empirics for just a minute, because we seem to be going back and forth on whether or not there is a litigation explosion. And after we hear that, I wanted to ask Noah Phillips if you could just for the moment assume, for the sake of argument, there has been no litigation explosion. Is the Innovation Act still then necessary? And assuming no litigation explosion, again, would the Innovation Act be at all corrosive or eroding of property rights? So, Adam, Professor Mossoff.
Okay, so, yeah, so I identified the Besson and Moyer study, the $29 billion, just because I didn't have time to talk about the others, but all of the other ones, the studies being repeated by Noah, with all due respect, I mean, I saw the studies, so I looked at the conclusions, and I said, okay, let me look at the data. And they suffer the exact same problems as the Besson and Moyer study. So the recent Harvard and Texas study that you cite relies upon the same discredited data from patent freedom that Besson and Moyer rely upon. Moreover, those numbers that you're citing to, when you actually go behind it and look at the methodology, not just the conclusions, you actually discover that the people that you're attacking as creating those problems include manufacturers, include individual inventors who've invented. Moreover, their specific losses that you cited is based upon a data set that is numbers 35. 35. From which they have extrapolated a claim about the industry as a whole. Now, I'm not formally trained in statistics, but I'm fairly sure that, you know, when I took statistics back in college, that if I had a data set of 35, my professor would say, can't draw conclusions from that. And this is, again, the problem, is that people are accepting conclusions of what is inherently biased, faulty methodology, biased data being produced by biased entities, and it's the conclusions that are ultimately driving this policy debate, creating, as I said, Dave Kaplan says it refers to as a fact-free zone, but in fact, it's, as I said, it's better characterized as a fiction free-for-all zone, where numbers are thrown about as if they are established and true when they are in fact not. And you know, one of the greatest things that I've always admired about the right, about libertarians and conservatives, is that historically they've always cared very much about getting truth right. about basing policy and legislative enactments upon what is actually happening in the real world and what is going on, and questioning whether more legislation is the answer, or is this simply a phenomenon of which we let the market and the property and owners of property rights work out the situations and problems that they have. And I'm concerned that we've flipped, and that we are now creating and repeating the same mistakes that the left has made at times when they create rhetorical devices that drive legislation and make massive changes to market actors and to property rights owners. And so I just think we need to step back. If we're going to have legislation, we need to make sure that that legislation is not just based upon theory, but is actually based upon truth. And that we don't even have established that yet.
Mr. Phillips.
There is a part of me that wants to toss a question at Professor Mossoff, which is, can you talk about some of the specifics of the legislation? But let me answer, Dean, the question you asked, if I remember it correctly. I think what you asked me was, assuming Professor Mossoff is right about everything and that everybody else is wrong, is the Innovation Act still a good idea? I don't accept the premise of the question, but I would argue that if you consider the reforms in the Innovation Act, the actual reforms proposed, not a rhetorical position about reforms in general, not a reflexive reaction to anything with the word property rights attached to it, that they are fundamentally modest in nature, and that they make the patent litigation environment just as similar reforms would make other litigation environments more sensible. The notion that, and I realize I'm running up against something when we talk about rhetoric, the American rule, the notion that if you bring a case which is objectively unreasonable, it's outside the bounds, that you should not have to pay the other side's fees, doesn't make sense to me. I don't think that's the right rule. The notion that you have to announce what your grievance is. What is your property right? What is the extent of that right? How does the instrument that you are accusing trespass upon that right, to borrow the property terminology? Those are good rules. There's a lot in the Innovation Act. We can spend time talking about it. But I do think that a lot of these are very good rules that even were Professor Mossoff 100% right, that it still would be a good idea.
Can I just ask?
Just 1 second before you do that, Commissioner Keefe. Let me ask the audience if you have questions to begin to line up. We're going to continue this discussion, but we're going to turn to your questions momentarily. Commissioner Keefe.
I'll ask questions in the hope of joining the conversation between the two views presented and to embrace what Noah has pointed out as a request for specifics. If I hear you correctly, you're highlighting the benefits that come from two things: getting parties together very, very early in a litigation before costs get high, maybe even before, and maybe even the party who brings it doing a lot of the homework first, and disciplining them each to be careful so as not to, in effect, waste each other's time. You might call that not a loser pays, but a bad loser pays. You should have known better type rule. So with that in mind, I notice, and we're grateful to still have Chief Judge Michel with us, during the so-called pro-patent days of the Federal Circuit, at a time when Judge Michel was there sitting. Let me ask you about two cases. I'll briefly tell you about them. See if they are examples of good things in your mind or bad things. And if good, why are they not good enough?
Can I object to a compound question?
Yes, of course. And it's in the spirit of moving the debate between you and Adam closer. There was a case at the Federal Circuit colloquially called Judin, J-U-D-I-N.
That's an awful name.
It is. It's named after the person. It's a last name. It happens to have been, we have Judge Braden here, it happens to have been a case originally brought against the United States government, the post office, but as often happens when the United States is sued, the product that it bought from someone else. So Hewlett-Packard, the company that provided the product to the government, stepped in on behalf of the government to defend. The infringement action involved some optical technology inside a handheld wand that a postal worker would use to scan. And the pre-filing investigation conducted by the patentee on the record seemed to have involved no more than once walking into a very, very large post office about the size of this room, glancing several hundred feet across and noticing that a wand was being used. And keep in mind the patented technology was internal technical optics inside the wand. That was the extent of the pre-filing investigation. And on that record, after the trial court decided not to award fees, the Federal Circuit, in an abuse of discretion review, decided it was an abuse of discretion to have not awarded fees. Turned out there was no infringement. And the Federal Circuit pointed out that that was a laughably insufficient pre-filing investigation to glance all the way across the room and conclude something about the inner optical workings of the wand. And the Federal Circuit, in fact, remanded the case to the Court of Claims for an adjudication of the amount of fees and an allocation of fault among the patentee, the patentee's trial lawyer, and the patentee's appellate lawyer for bringing and sustaining such a frivolous case. So that's an example where during the so-called pro-patent days, the Federal Circuit sanctioned the patentee's lawyers, plural, for not doing the kind of good work that I think you're describing one should do. So is that an example of kind of good behavior by a court to sanction that kind of bad behavior by a party? And would you want more of that, less of that? Will your bill help that?
To be clear, it's not my bill. It's
Sorry.
the senators.
Would the other bill? Yeah.
And we were talking a lot about the House bill. The first thing I'd say is it's clear that that is not enough pre-suit investigation. That's shameful. You can clearly see how the court got to where it did. It seems to me, and let me say in the abstract, and this is a really awful thing to say in front of a Federalist Society audience, and as a lawyer, what the courts did in general seems to have been, at the end of the day, the right thing. It seems to me that because you're dealing with an abuse of discretion standard, it raises another issue about appellate review and what abuse of discretion means. When I was a law clerk, that was my judge's first question. What's the standard of review here? And I think I'd have to grant that there at least seems to me, notwithstanding my preference for the policy outcome, a real question whether that happened. I'm not intimately familiar with the case. Certainly it seems like that is a case where fees ought to have shifted, and that perhaps liability for those fees ought to have been apportioned between the patentee, their lawyer, and their appellate lawyer. In terms of what the bills would do, the Innovation Act, I'll take that as an example, changes Section 285. Section 285 now grants courts that discretion in exceptional cases to award fees. What the Innovation Act would do is it would say within certain limits, if something is substantially justified, that's a standard borrowed from EJA, with which the Court of Federal Claims certainly is familiar. If you fall outside that ambit, the court has an obligation to shift fees. It would go from the discretionary to the default. And that change in instruction from Congress presumably will lead to judicial behavior that will increase the incidence. So
and then
I think yes.
Okay, so then I'll just briefly mention the second case, which is the Johns Hopkins versus Celpro case, also out of the Federal Circuit, where the next mechanism by which people often discuss bad behavior of parties is the behavior of counsel to, in effect, dress up bad behavior with an opinion of counsel. Hey, lawyer, you're my lawyer, I pay you a lot. Couldn't you just write me an opinion that says my behavior is not so bad, and then wink, wink, nudge, nudge, I'll be protected. And the Federal Circuit showed itself to be quite astutely careful in those kinds of deals. And in that case, the trial judge, in fact, out of the District of Delaware, using language that was pretty explicit, referred to the situation in that case. A practicing partner at a fairly well-known law firm on the West Coast had written an opinion of counsel for a client whose in-house lawyer was a former partner at that firm, and the opinion of counsel was, I'm a former law professor, I would say this is a fair characterization, it was a non-issue spotting opinion, the way you would not like to write a final exam in law school. It basically did not cover anything.
This raising further questions about whether the practice of law and what they're teaching in law school line up with one another.
Yes, well, although apparently they did, right? Because it turns out very, very harsh language out of the District of Delaware, naming both partners and the firm. Slightly more subdued language out of the Federal Circuit affirming the district court decision. And within a very, very short amount of time, one of the very, very good, long-standing, old, famous intellectual property firms disappeared because the market sanction was extraordinary. They had written a laughably bad opinion of counsel. Everyone caught it. The emperor, in fact, had no clothes, and everyone said so. And the sanction was pretty immediate and pretty complete. Is that the kind of disciplining you like to see?
So this again raises an issue that goes outside the specific context, I think, of patents, and this has to do with, first of all, how law firms conduct themselves, and second of all, what the impact of a sanction can have on a firm as a whole. It's something that echoes, I believe it was an antitrust litigation in which Donovan Leisure was involved, where documents were deliberately misplaced and withheld from the other side. We don't have that firm anymore. I'll go a little further if I may. Enron. Their accountants didn't play nicely. They were indicted. The Supreme Court ultimately said that was wrong, but there's no such firm anymore. So I think that one always has to take great care in dealing with an entity that fundamentally is built on credibility and trust and has little more than its people. You always have to be very careful in those situations. I would argue that you need from time to time for sanctions like these sometimes to happen.
Demonstratives.
Right. Demonstratives as a sort of ex-ante check on bad behavior. It gets, I mean, I think everyone would agree, it gets hairier when you're dealing with lawyers, accountants, other kinds of advisors. One apple can spoil the bunch. And that's clearly what happened in this case. With respect to how the bills deal with that issue, I don't think, other than increasing the likelihood of fee shifting, they do much about that.
Professor Mossoff, do you have anything on this point before we go to the other?
I would like to actually hear questions from the audience. So I think that would be.
The gentleman in the back stood up a few minutes ago. You still have a question, sir? And others could go to the microphone. If you'd use the microphone.
Yeah, I would appreciate it if he would go ahead and ask his question, the professor. Were you going to ask a question of the gentleman to your right?
No, go right ahead with your question.
Okay. this is directed to the Senate staff member. I take it that you are a litigation attorney?
Yes. Or at least I was.
Could you tell me a little bit about discovery? Have you ever conducted a patent litigation?
I've been involved in patent litigation, yes.
Which side, plaintiff or defense?
We were the defendant in that case.
So you've never done really a preview and understand how that is a pre-litigation, patent litigation investigation?
No, I have not.
Do you think that those things are easy to do, those kind of investigations?
No, I don't.
And do you think that it is possible that you could do that and not be able to get at all of the details in, say, a wand, the electrical things? Because you are not going to be able to find that, even get a hold of it. Would you agree with that?
I think from time to time that could happen.
Okay. So then discovery, lack of discovery, is not necessarily a problem under this new act. Is that correct?
I'm not sure I understand. The lack of discovery is not a problem.
If you're a patent plaintiff, you have exhausted all of the efforts that you can make to actually see or get a hold of and test the article, which is most likely, then that would not come under your new
I guess what
amendment to the act.
he may be asking you to just talk more about how you would address the concerns of a patentee who tries in best faith to ascertain whether there's validity in infringement, but has to satisfy the pleading standards without perhaps having access to the internal information of the other parties in the marketplace.
Sure. I mean, I'll take as an example the Innovation Act. That's the House bill that passed last year. For some of the obligations with respect to pre-suit disclosure, the obligation was only on the plaintiff if known, right? So if you didn't know, you weren't obligated. Exactly how this would be dealt with was a matter of great discussion at the House level, also among Senate staff as we worked on our compromise.
One final question here. Are you familiar with the General Electric Company?
Yes.
Thank you. Yes, most people are.
I think there's a follow-up question.
Yes, correct. How would you characterize Thomas Edison in his very earliest patent?
I think I'd use the conventional characterization that he's an inventor.
That's correct. But then, what did he do with that first patent? Did he practice it?
No.
No. So he's a non-practicing entity, correct?
Yes.
Okay. And if he hadn't been a non-practicing entity...
Let me back up for a moment. As Professor Mossoff said earlier, there is, some discrepancy in how one defines it. But go on.
Okay. So who founded the General Electric Company?
Thomas Edison.
Thank you. That is a practicing entity, I take it.
Just to be clear, sir, and this is one of the reasons I think it's really important not just to get involved in simple rhetorical arguments, but also to look at the facts. Are
you saying that Thomas Edison didn't found the General Electric Company?
I think we can all agree upon that.
Let him answer the question.
One of the things that you see in the House bill is a concerted effort, not a perfect one, but a concerted one, to try to come up with neutral rules that apply to all entities. So whether Thomas Edison was a non-practicing entity wasn't necessarily material.
Why not?
Well, if the rule is the same whether you are or not, why is it?
Well, non-practicing entities do not have the power of General Electric. Any of them.
Are there other questions from the audience? I think we've gone down this road enough.
The,
Adam, you
well, there's a question, so I don't want to preempt the question.
So I'm Alec Rogers. I work for Xerox. You know, we invent things. We litigate. We're on both sides of the table. We're plaintiffs. We're defendants. Sometimes people we sell intellectual property to get involved in litigation. I mean, you know, as a company, we don't take a really strong position when it comes to the substance. We're not trying to tip the scales one way or the other. We are concerned, though, about the costs of litigation. I think we'd like a fairer, faster, less expensive resolution, win, lose, draw. We want to be able to enforce our patents faster. When we get sued frivolously, we'd like to get that kicked out of court faster. So I guess my question is primarily directed to Professor Mossoff, and that is, you know, do you believe that the system, the litigation system, is perfect as it is? Or are there reforms that you could get behind? It seems like there's a basket of ideas, and maybe there's at least a few that everyone could kind of rally behind and say, these are all good, and you know, maybe we can get half a loaf, or I'm just curious as to your views on that. Thank you.
That's a great question. Is, you know, how is the patent system functioning? Is it functioning in a great way or not in a great way? And that's a very difficult question to answer empirically, because it depends upon what your baseline, your standard of reference is. And one of my concerns is that the baseline is what economists sometimes refer to as the nirvana fallacy, where they posit a kind of perfectly functioning, kind of theoretical notion of, well, of how the system should function. And then, of course, by comparison to that, the current institutional arrangements are just an utter failure. They're abysmal. And so any change would seem better, especially since we have no empirical verification of how that new change is going to work out. And so let's adopt that change. And we have tons of examples in history of this. So this is not just a positing of a classic kind of professorial hypothetical. In 1996, the Supreme Court said, you know, what will reduce patent litigation is establishing very early on the meaning of the patent terms. So this is the Markman decision from the U.S. Supreme Court, one of the very few Supreme Court decisions in the 1990s with respect to the patents. They said this will lead to more efficient, faster, less costly patent litigation. And what did it actually end up producing is what are now known as Markman hearings, which are pre-hearings before you even get to infringement that can cost upwards of over $1 million in costs. So has experience borne out what the Supreme Court has said would happen? I don't know. The Innovation Act, not the Innovation Act, the American Invents Act is another great example where they said litigation is very expensive. Let's create alternatives to litigation at the Patent Office. Let's create more administrative review programs, post-grant review, inter partes review. Additional programs, ways in which people can address bad patents and more quickly and more efficiently eliminate them. I think that that's an aspiring ideal. We should work towards tweaking the patent system constantly to make it better. But what was the concern there was that everyone just assumed that these administrative procedures would just function perfectly and efficiently, and they wouldn't be abused by potential infringers, and you wouldn't have the inherent inefficiencies that come with running an administrative process that comes into play. And what we have seen borne out over the past couple of years now is that actually there is serial and abusive filings at the Patent Office now, where in fact there was a court case where a particular serial filer of post-grant review oppositions was actually was found to have been extorting patent owners by going to patent owners and saying, if you don't pay me, I am going to tie up your patents at the Patent Office, and you will be and your patents will be valueless during that time. And so what I'm worried about is what we have now is perceptions, or patent litigation is expensive. Yes, all litigation is expensive. And the perception that we'll adopt these changes and they will work great. They will fix these problems. Don't worry, we're from the government. We're here to help. And we are not actually aware of or sensitive enough to the fact that, A, these changes create additional uncertainties. As the new rules are implemented, we have no idea what's going to follow from that, unintended consequences. And B, they can be abused just as much, and as the current system is abused. And I think that we need to be sensitive to, earlier there was talking about the symmetry principle. The symmetry principle applies to concerns about costs and abuse. Patent owners can be abusive, defendants can be abusive. And right now, there's all this discussion. All of the data is on allegedly abusive patent owners. And there's zero in the current patent policy debates about what happens on the defendant's side. What's the cost of actually enforcing patents? What's the cost to licensing of changing patent rules? We have no data on this, zero. That's very revealing to us, isn't it, that the patent debate is entirely one-sided with respect to so-called data? And there's no one's even asking these questions about the other side. And so I'm very concerned that we're engaging in a nirvana fallacy. With respect to some of the issues and concerns, I think that they're being addressed. I think that octane fitness was a good step. That in lowering the standard of review and bringing award of attorney's fees more within the discretionary authority of courts, and in fact attorney fees are now being awarded at a much higher rate. It doesn't seem any day now that I don't get a new email notice about a district court awarding attorney's fees or costs. The judiciary has stepped in and has changed the pleading standards that Noah has talked about. Form 18 has been, the Judicial Council, which is in charge of the standards for coming up with filing of complaints, has voted to eliminate Form 18, to heighten the pleading standards. So I'm a believer in not just federalism, but in separation of powers, and that some of the problems that are being complained about, which are legitimate problems, are within the scope and area of the judiciary to address. They're docket management issues, they're pleading standard issues, and these are historically and traditionally within the power of the judiciary to address, and they're addressing them. The Supreme Court's addressing them, the Federal Judiciary, the Judicial Council's addressing them, and the Supreme Court has been issuing, as you heard from Judge Michel earlier, numerous decisions, not just on attorney's fees, but on what patents can be awarded. So there's a lot of disruption, especially in the past couple of years, about what one can do in the patent system that are addressing some of the issues and concerns about costs and other issues that people have. And my position is let's see how those play out. Let's step back and let's see how all of these changes have played out before we change the system again and create more uncertainty and potentially more new problems down the road the way that we've seen created in the past. Commissioner Key.
I just want to throw out some further background just to tie in cost and to compare across institutions and to tie some themes together from my initial remarks. So the International Trade Commission where I work, our cost to you, the public, our budget is around $80 million. You may think that's a lot, you may think that's a little, but let's just notice that the Department of Justice Antitrust Division, very active in monitoring and modulating the interface between IP and antitrust, features in its budget statement to Congress its special focus on patents, and its budget is twice that, $160 million. So it's costing you twice that. Of course, it does some other things. By the way, we do other things too. The Federal Trade Commission from this morning's panel also features right up front in its budget to Congress its focus on patents and its enhanced focus on patents. Its budget, twice that yet again, $300 million. And the Patent Office, bolstered by these new proceedings to better police patents, its budget, twice the twice and 10 more times, $3.5 billion with a B, 10 to the 9th. So when you ask yourself, what is that money for? And you think about the difficulties that parties have when trying to suss out whether there is infringement and whether there is validity or invalidity, turns out that that information, those types of information, are very, very, very hard to get. They're very expensive. And the Patent Office, with its $3.5 billion budget, is not getting that information. That's not what the money's used for. The Federal Trade Commission and the Department of Justice Antitrust Division, the same, as Commissioner Wright pointed out. These are organizations that are using the money to do something else, something that's totally appropriate for government to do, which is engage in very serious democracy-based policy preferences. But if you want there's no free lunch. So if you want your agencies to focus on rewarding lobbyists and paying lots of attention to policy when doing their adjudication, you want them to have billions of dollars or hundreds of millions of dollars or budget so that they can receive the outreach that is congenial for that kind of input, so that they don't have to rely on building the very, very expensive for the party records that have to get built through discovery. District court litigation and ITC litigation, we have discovery. It's expensive for the parties. It is. That's a cost. But a benefit is it's facts. It's a set of facts and a factual record. And then the chips fall where they may. And district courts and ITC litigation are quite immune from political preferences and quite immune from policy preferences. And if you like that trade-off. And if you want a different trade-off, then you want the much more expensive, larger government apparatus designed to rely on administrative law deference principles to build records that are not based on a factual record, but records that are based on policy input. And that's the trade-off that's on the table today, and has been on the table for quite some time. Neither is perfect. They're both fraught with problems, and you have to decide for yourselves which ones you want to use in which settings. But those trade-offs are very, very clear, and the numbers are what the numbers are. Let me just highlight one other feature of district court and ITC litigation that is not present in the kind of validity-focused or invalidity-focused proceedings that happen at the Federal Trade Commission, the Antitrust Division, and the Patent Office. You talk about rhetoric, and we all like dialing down rhetoric, and that's a good thing. But there is a feature of district court litigation and ITC litigation that is anti-rhetoric, and it goes like this. When you have in a single proceeding validity and infringement and remedy all on the table for discussion at the same time, the incentives for each side to engage in rhetoric go way down, and here's why. If a patentee is asserting her patent on offense, she has an incentive to say rhetorically that her patent is uber powerful. It covers the world. But if she knows that a moment later she will have to protect her patent on defense, she will then think to herself, while on offense I want to say that my patent is very broad, on defense I will want to say that my patent is very narrow. If I overplay my hand in time one, I will get it bitten off in time two. Similarly for the alleged infringer, if the alleged infringer says, oh, come on, your patent is so broad it covers the prior art and all prior art, and oh yeah, by the way, it doesn't cover me, that's a tough argument to make. As Judge Rich always pointed out, the stronger a patent is, the weaker it is, and the weaker a patent is, the stronger it is. And when both sides to a litigation know that, and both sides know that they have to argue both sides of that coin at the same time, then both sides of the argument have their own selfish incentives not to engage in hype. And the very, very expensive proceedings that we and other parts of the world have used to separate out validity from infringement have a disadvantage, and a disadvantage is more hype, because you separate out the self-disciplining that otherwise is present.
I think we're going to have to let that be the final word. I will disagree with Commissioner Keefe just one little bit. There is such a thing as a free lunch. It's across the hall in about 10 minutes, so we'll see you over there. Thank you all.